Welcome to the City Buzz Mobcast. This is your host, Mista Solo. Today we are having a little discussion here about the legal standpoints and the legal views of our system. I'm in the state of Ohio. I don't know what state you may be in, but if you're in a different state, maybe this don't apply to your situation. But Ohio has a stand your ground law. It's called SB 175. Ohio Governor Mike DeWine signed a bill on January the 4th, 2021 that eliminates Ohioans' duty to retreat before using force. That law went into effect in April of 2021. So let me rewind this a little bit. It's saying that you are no longer, it eliminates your duty to retreat before using force. So that means that if you don't have to retreat. Got that. That's one thing. Okay, let's move on. Okay, the measure expands the stand your ground right from an individual's house and car to any place, if that person lawfully has a right to be there. I'll say that one more time. This measure expands the stand your ground right from an individual's house and car to any place, if that person lawfully has a right to be there. Okay, the law specifies that any means of self-defense and lethal force may be used if you did not start the situation or escalate the situation, and if you're in fear of immediate death or bodily harm and have no other option except for deadly force to survive the situation. Now, the evidence, what separates stand your ground from anything else. Okay, clearly the law specifies that the person using the self-defense is protected by this law if the person is not the aggressor. The person believes they are in imminent danger of death or serious bodily harm. The person is in a place where they have a legal right to be, and you're not trespassing. Now, the Governor DeWine said, and I quote, "I have always believed that it is vital that law-abiding citizens have a right to legally protect themselves when confronted with a life-threatening situation." Now, this is not a free pass to use lethal force against another, because once you get in the courtroom, this is when the legal aspect comes in. Okay, let's say, for instance, you're at the grocery store. Some guy just keeps on, he just keeps on like he wanna get at you, like he wants to smoke or something. So then, what? You let him have it. You give him the smoke and the fire. You hear me? You break him off the complete dial and blow him away. Now you got to go to jail. You going to jail, and you got to sit there in jail for the 90 days with speedy trial. Now I'm gonna break something down to you before we get into the finish this here. That 90-day speedy trial, I'm gonna tell you about that in a minute. But now you sitting in there and it says a trier of fact shall not consider the possibility of retreat as a factor in determining whether or not a person who used force in self-defense, the defense of another, or defense of that person's resident, reasonably believe that the force was necessary to prevent injury, loss, or risk of life or safety. This person is on your property. He don't have no right to be there, or she don't have no right to be there. You ask them to leave. They don't leave. You don't have to call the police. You can pick up a brick, bust their head over, but you're going to jail because you got to go in there and prove that the incident that happened, it was not, you didn't cause the incident, and so forth and so on. You got to prove that the other person was the aggressor. So before y'all go into this self-defense thing, have your witnesses, have everything lined up, make sure that you're in the right. Because I'm going to tell you something about this. Ohio has a speedy trial law. 90 to 270 days for a speedy trial. 270 days is if you are not in jail in lieu of bond. They have 90 actual days to try and convict you if you are in jail in lieu of bond. As Ohio Revised Code 2945, 71, 72, and 73. Just in case you didn't know. So now, what they're doing up here in Ohio is they are violating people's speedy trial rights. They keep people in the county jail for more than 6 months. You have 90 days. And then Ohio Revised Code 2945, 72 states that each day that an individual, that the accused is in jail in lieu of bail, each day shall count as 3 days. Okay? So you got 90 days for your speedy trial. Every day that you in jail counts as 3 days. How many days you got for your speedy trial? Come on, mathematicians. Okay, right. Do the math. Do the math. So you actually don't sit in jail for 90 days. You're not supposed to sit in jail for 6 months, a year in the county jail waiting for a speedy trial. If anything like that has happened to you, stand up and speak out for yourself because your rights have been violated. Now, I just want everyone to know that you'll be okay. And if you ain't heard the buzz, you ain't heard City Buzz.